Nicholas Lopez, Code Compliance Officer.
Sam Schaller, Assistant Fire Marshal.
Thank you. All right, will you please join me in the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Next on the agenda is my statement about how the hearing is going to run this evening. I am going to read this so I don't forget anything, so forgive me. We are here tonight because the City of Deltona has contended that there are violations of the Deltona City Code that exist. This is a public meeting, which means that no general public comment will be accepted, but each of the respondents and the code enforcement officers here tonight and any witnesses each of you call will be able to present evidence to me regarding each case and the violations of the Deltona City Code that are being alleged. I am an attorney and appointed by the City Commission to render decisions in these code enforcement cases to determine if a violation of the City Code exists and what fine will be imposed, if any. If you are here for a Massey case, you might see that next to your case number on the agenda. That means that I will be determining solely whether you have come into compliance in a timely manner in accordance with the previous order the special magistrate issued in your case, and will not be reopening the case to determine whether or not a violation existed in the first place. Any decision I make this evening will be put into a written format in the form of an order. A copy of my written order will be provided to the city and then mailed to you as well. It is important to note that for any order I issue, you may appeal by sending a written notice of appeal to the circuit court within 30 days of the execution of my order pursuant to Florida statutes, section 162.11. The procedure of the hearing today will be governed by Chapter 162 Florida statutes. Formal rules of evidence shall not apply, but fundamental due process shall be observed and shall govern the proceedings. Hearsay is admissible, but only to support other competent and substantial evidence. If you are a respondent, you will be able to testify, tell me what you think I need to know about your case, present evidence and witnesses. Your testimony will be under oath, so I will be swearing you in, and this hearing is being recorded. For each case, I will call the case number and the city will proceed first. The city has the burden of proving that the code violation exists, then you will be allowed to respond. For each case, I intend to admit the case file and the PowerPoint presentation that is shown, and you should have received a copy of that when you came in this evening. If you did not, please let me know. And I intend to admit that into evidence unless a specific objection is made. I will take the cases in the order that you signed in, first come, first served. And I do have some cases that, I have quite a few cases that have been continued or withdrawn. So should I go ahead and read these? Okay. All right, the continued cases are Fire 24-0028, 2090 Saxon Boulevard, Suite 102. Fire 24-0030, 305 Fort Smith Boulevard, and DEL 24-055 A and B, 1743 West Chapel. If you're here for any of those cases, then they are being continued to to June, to the June meeting, and you do not need to stay. The withdrawn cases are as follows. DEL 24-036, 1250 Cortland Boulevard. DEL 24-017 A and B, 2435 Academy Avenue. DEL 24-039, a Massey case, 1812 North Akron. DEL 24-056, 2543 Maximus Court. DEL 24-058, 1962 English Drive. DEL 24-059, 1962 English Drive. DEL 24-060, 1962 English Drive. I also have Fire 24-0016, a Massey case for 1120 Elkham Boulevard. Fire 24-0017, Massey, 2820 Doyle Road, Suite 12. Fire 24-0019, Massey, 3151 Howland Boulevard. Fire 24-0023, 1680 Doyle Road. And Fire 24-0025, a Massey case for 1800 Elkham Boulevard, Suite D. Fire 24-0029, 1701 Doyle Road, Suite B. And Fire 24-0031, 840 Deltona Boulevard, Suite C and D. So if you're here for any of those cases, that has been withdrawn and you do not need to stay. All right, I will go ahead and swear in everyone who intends to testify today as a group, which includes the code enforcement officers. So if you plan to speak to me this evening, please stand and raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth? If so, please say I do.
I do.
Thank you. All right, we will go ahead and get started with the cases. Oh, and I do not have any ex parte communications to disclose. All right, so the first case is Fire 24-0018, a Massey case, 2320 North Normandy Boulevard.
Good evening.
Good evening.
For the record, my name is Samuel Schaller. I'm employed by the City of Deltona as the Assistant Fire Marshal. This will be case number Fire 24-0018, the City of Deltona versus 2320 North Normandy SP LLC. Property address is 2320 North Normandy Boulevard, Deltona, Florida 32725. Parcel ID is 811-805-000020. This is a Massey case. Statutory requirements for notification of this hearing have been met. The notice of hearing and notice of code violations were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted at City Hall and on the property at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. This was initially a case for a violation of Chapter 42, Article 4, Fire Codes, Chapter 42-186, which adopts the latest edition of the Florida Fire Prevention Code. In specific, the Florida-specific version of NFPA 1 Fire Code, Section 18.2.2.2, which states the AHJ shall have the authority to require fire department access to be provided to gated subdivisions or developments through the use of an approved device or system. 18.2.2.3, which states that the owner occupant of a structure area with required fire department access as specified in 18.221 or 18.222 shall notify the AHJ when access is modified in a manner that could prevent fire department access. And Chapter 1.7.12.10, which states no construction work shall proceed till the authority having jurisdiction has reviewed the plans for compliance with the applicable codes and standards and the applicable permits have been issued. It was ruled on February 28, 2024 that the property owner was given 30 days to comply. The owner did not come into compliance within those 30 days, has been receiving a fine of $50 a day since March 30th, 2024. As of today, the property has accrued a total fine of $2,700 over 54 days. In closing, City is requesting that the fines continue at $50 per day till such property owner has notified the City of compliance and compliance is verified by a fire safety inspector.
Thank you. I'm having some difficulty finding my order. Is it in here? Give me a moment. don't see the order. However, okay, so I don't see the order in here. Can you, I believe that I only found a violation of 18.2.2.2 and chapter 1.7.12.10. Is that correct in my order?
That's correct.
Okay. So they have not obtained a permit yet for the gate access change, and there was remind me, there was a Yelp gate function.
Yes, Your Honor, the Yelp gate opener so we can get in and out of the property in an emergency situation, that doesn't function as well.
Okay, and so that has not been, a permit has not been applied for yet?
A permit has been applied for. Actually, I wrote down both permit records here. Permit ELEC 24-0014 was applied for on March 18, 2024. However, the only thing attached to the permit, it was submitted online, was a blank permit application with no scope of work provided other than the words low voltage. The applicant was emailed by a permit clerk on March 27, 2024 regarding needing a scope of work and a filled out permit application. Nothing was received. On May the 17th, 2024, we received another permit application, ELEC 24-0034. That was received 4.5, 5 days ago. It hasn't been assigned to a reviewer yet. I went ahead and looked at it today. The only thing that's on there is a filled out permit application. No specifications for anything that was done, no product approvals, no UL listings, things like that.
Okay, all right, thank you. And then the section 18.2.2.2 is with regard to access, correct? And
Yes, ma'am.
has that not been provided to the fire department at this time?
No, Your Honor, I've made multiple site visits up until today. My vehicle's equipped with a siren. I've tried the Yelp feature. I've tried every siren function I have. Nothing opens the gate.
Okay. Is the property owner here? Would you like to come forward?
Yes.
Hi. Can you state your name and address for the record, please?
The address is, what is the address? 2320 North Normandy.
Okay, what would you like to tell me about the case?
Unfortunately, I don't have any excuses. The vendor that we're using has, he's assured us that he's working on getting the permits applied, but after the news of today, it doesn't sound like that's been the case. As well as the Knox box that he ordered 6 weeks ago, that still hadn't shown up. He ordered another one supposed to be in tomorrow, or Thursday, to be installed on Friday. He told us that the Yelp function was working. But obviously, we can't test that, so the fire marshal's saying otherwise. So unfortunately, I don't have anything to say other than it hasn't gotten done yet. So I apologize to the court on that. And as far as the fines, I don't remember hearing about, obviously I can read about the fines, but I thought we were waiting until the next one to, as far as start accruing the fines, so.
Well, I ordered that the violations be corrected by a certain time, which was March 30th. And obviously, we're well beyond that. So if you have anything further, Mr. Schaller? All right.
No, ma'am.
I'm going to go ahead and make my ruling that the respondent in this case failed to correct the violation by the time specified in the special magistrate's prior order in this case, and the fine will be imposed as set forth in that order and will continue to run until the property is brought into compliance and an affidavit of compliance has been filed by the code inspector. Respondent shall notify the code inspector to verify compliance, so please make sure you stay in contact with Mr. Schaller. And I hope you can work with your contractors or whomever to really expedite things. And I'm also, for the record, I'm admitting the case file in the PowerPoint, so Thank you.
All right, thank you.
Thank you.
Okay, the next case is 24-061, 1510 Howland Boulevard.
Good evening.
Good evening.
My name is Nicholas Lopez. I'm employed by the City of Deltona as a code compliance officer. This will be case number DL24-061, the City of Deltona versus William Waldman. The property address is 1510 Howland Boulevard, Deltona, Florida 32738. The parcel ID number is 813-043-620-250. This is a violation of City of Deltona Ordinance, Section 18-3, adopting the latest edition of the Florida Building Code, Section 105.1, which states that any owner, authorized agent who intends to construct, enlarge, alter, repair, move, demolish, or change the occupancy of a building or structure, or to erect, install, enlarge, alter, repair, remove, convert, or replace any electrical, gas, mechanical, or plumbing system, the installation of which is regulated by this code, or to cause any such work to be done, shall first make application to the building official and obtain the required permit. Corrective action for said violation is to: you must obtain a permit for the shed addition. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. On February 15th, 2024, formal code compliance officer Tyler Russo received a complaint regarding the shed being located in the city easement. On April 16th, 2024, per the directive of code compliance manager Danny Ron, a notice of violation was issued to the resident by myself. As of today, May 22nd, 2024, the property is still in violation with no permit on file. The city would like to request 30 days for the property to come into compliance or a fine of $25 per day to be imposed until such time that the property owner has notified the city of compliance.
Could you point out to me what the structure is we're talking about that was constructed?
The shed, in the portion of the shed that's highlighted in the property appraiser's records, that's the part of it that was constructed, without a permit, and it is located in the city easement. And again, that's the yellow highlighted portion that's shown in the picture.
Okay, so we're looking at picture 3 for the record, so it's the yellow highlighted?
Yes, ma'am.
Okay, and then is it shown in another picture? Is it?
The part of the shed that drops down and then protrudes out, that's the part that's in question.
Okay, where there's like a white roof kind of.
It transitions from white to brown. It almost makes an L. The part of it that looks brown or darker, that's the part that was constructed without a permit.
Okay, but this is a shed? Is it
Yes, ma'am.
attached to another shed?
Yes, ma'am.
Oh, okay, it's enlarging.
It's a shed addition. That's what we would consider it.
Okay, all right. Okay, and it's your testimony that there's been no permit applied for?
Yes, ma'am.
Okay. Is the property owner present? Would you like to come forward? Can you state your name and address for the record?
William Waldman, 1510 Howland Boulevard.
Okay, what would you like to tell me about the case?
That structure, if you could have made a wider picture, is on both sides of that 24 by 60 building. It was built in 1985 when the house was built. So that's when it would have been permitted. If you want to go there and take a field trip, you can go see you have 30-year-old 6 by 6 like posts embedded into the ground, a truss system connecting where the white comes down to that section to support the roof. 30-year-old fasteners that they probably don't even make anymore, and 30-year-old hardware. That building has been there since the house was built in the 80s. Before all the other houses were around, that was a tack room because they used to have horseshoe tournaments there. And it's been there since the house was built.
The shed addition was there since
The
1980?
whole structure was there.
Okay. And so for the city, do you agree with that statement?
I would have to disagree because I went back and researched some property appraisers. I didn't see anything past I would say the 90s. The quality is just too difficult to tell whether if it was there or not with the older technology. Again, this was submitted due to a complaint. So the issue at this point is the shed being located in the easement. So that's why we're here.
Okay. Well, that's not the violation that was cited. The violation is
Right.
for a permit. So, I'm not hearing very good, evidence that this was added at least any time recently. So I guess I would say either, I can continue it if you'd like to bring me further evidence, or otherwise I'm not sure how to find that there was a failure to obtain a permit if it was there, as the gentleman's testified, it's been there since it was constructed in the 80s.
We can go ahead and continue the case.
Okay. I will continue the case until the next meeting. It will be on July 2nd is the next meeting. And we'll take a look at it then. Okay?
Okay.
Thank you, sir.
Thank you.
All right, the next case is Fire 24-001, Massey case, 1712 Doyle Road.
For the record, my name is Captain Samuel Schaller. I'm employed by the City of Deltona as the Assistant Fire Marshal. This will be case number Fire 24-001, City of Deltona versus Circle K Stores, Inc. Property address is 1712 Doyle Road, Deltona, Florida, 32725. Parcel ID is 813-0230-80010. This is a Massey case. Statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted at City Hall and on the property at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. This was initially a case for a violation of Chapter 42, Article 4, Fire Codes, Chapter 42-186, which adopts the latest edition of the Florida Fire Prevention Code, in specific, Florida-specific version of NFPA 1 Fire Code, Section 11.1.8, which requires all panel boards and switchboards, pole boxes, junction boxes, switches, receptacles, and conduit bodies shall be provided with covers compatible with the box or conduit body construction and suitable for the conditions of use. And Section 1.7.12.10, which requires a permit be issued by the authority having jurisdiction prior to any construction work occurring in a building. It was ruled on January 24th, 2024. The property owner was given 60 days to comply. The property owner did come into compliance with the violation of NFPA 1, Chapter 11.1.8 in that time frame. However, they did not come into compliance with NFPA 1, Chapter 1.7.12.10 within those 60 days and have been receiving a fine of $25 per day since March 25th, 2024. As of today, the property has accrued a total fine of $1,475 over 59 days. In closing, the city is requesting the fines continue at $25 per day until such property owner has notified the city of compliance and compliance is verified by a fire safety inspector.
Okay, so you said that so 11.1.8 came into compliance.
Yes, Your Honor.
Within time ordered, and then 11.1.2.2 did not?
That would be 1.7.12.10 did not.
Okay, but 11.1.2.2 also came into compliance?
Yes, Your Honor, that's correct.
Okay. And, okay, 1.7.12.10 required a permit for, it was electrical work that was done, correct, for cooking appliances?
Yes, Your Honor.
Okay, and so has the permit been applied for?
Yes, ma'am. One was applied for on April 23rd. It has not been issued yet.
Okay. April 23rd has been, about a month now. So is there outstanding comments or review comments on the permit application?
I don't have the permit, the status right in front of me. I know it's in review. I know it took a few days between the application to getting to the reviewer's desk.
Sure.
It's a pretty extensive permit. The property owner actually has gone ahead. They've included the electrical work that was done in the scope of this new permit. They've also included quite a few upgrades, such as they're bringing the bathrooms up to ADA compliance, fixing a few other electrical issues, so it's going to take just a little bit longer to review than a standard permit just for the dedicated 220 circuit for the ovens.
Okay, so they have included voluntarily other work in this permit application?
Yes, Your Honor.
Okay. All right.
I did.
Go ahead.
I'm sorry. If I may, I actually talked to the engineer of record about this permit. He stated that he simply wasn't comfortable with drafting the documents for just the electrical permit without including the remainder of the issues that he saw when he conducted a site visit in the scope of the permit, which is why it became so extensive.
Mm-hmm. All right. So, all right, but the compliance date was March 25th,
Yes, ma'am.
and it wasn't applied for until April 23rd?
Yes, ma'am.
Okay. All right. Is there anything else you needed to add?
No, ma'am.
Okay. I'm going to admit the case file and the PowerPoint as an exhibit, and I find that the notices were properly given in this case. I find respondent in this case failed to correct the violation by the time specified. Excuse me, let me be specific. Failed to correct the violation of NFPA 1, Chapter 1.7.12.10 by the time specified in the special magistrate's prior order in this case, and the fine will be imposed as set forth in that order and will continue to run until the property is brought into compliance and an affidavit of compliance has been filed by the code inspector. Respondent shall notify the code inspector to verify compliance, and I will find that the this would be NFPA 1, Chapter 11.1.2.2 and 11.1.8 came into compliance within
Thank you.
the time period ordered. Thank you. All right, this is Fire 24-0014, Massey case, 2901 Howland Boulevard.
For the record, my name is Captain Samuel Schaller. I'm employed by the City of Deltona as the Assistant Fire Marshal. This will be case number Fire-014-2023. The City of Deltona versus Cole FD Portfolio 3 LLC. The property address is 2901 Howland Boulevard, Deltona, Florida 32738. Parcel ID is 813-039-130080. This is a Massey case. Statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation sent certified mail to the property owner, the address listed with the property appraiser's records. In addition, both notices were posted at City Hall and on the property at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. This was initially a case for a violation of Chapter 42, Article 4, Fire Codes, Chapter 42-186, which adopts the latest edition of the Florida Fire Prevention Code. In specific, NFPA 1, Section 13.1.1, which states the authority having jurisdiction shall have the authority to require that construction documents for all fire protection systems be submitted for review and approval and a permit issued prior to the installation, rehabilitation, or modification of any fire protection system. It was ruled on February 28, 2024. The property owner was given 30 days to comply. The owner did not come into compliance within those 30 days and has been receiving a fine of $25 per day since March 30th, 2024. As of today, the property has accrued a total fine of $1,350 over 54 days. In closing, the city is requesting that fines continue at $25 per day until such property owner has notified the city of compliance and compliance is verified by a fire safety inspector.
Thank you. And so, was a permit applied for in this case, or hasn't even been applied for yet?
Yes, Your Honor. So in the time frame of after the initial hearing, the store was either robbed or vandalized. Someone actually came in and broke the fire alarm. They ripped the motherboard out of it.
Okay.
They were immediately notified of this, and the store is actually the property's actually since closed. There's no business operating there anymore. A permit was applied for, Fire 24-0027 was applied for on April 18th, 2024. However, the initial application was insufficient. It had no documentation attached to it other than a permit application. Our plan reviewer, fire safety manager, has had communication back and forth with the permit applicant, and I believe just a few days ago finally received an actual set of construction documents and specifications for the fire protection system to review.
You said they received the specifications a couple of days ago?
Yes, Your Honor, just a few days ago.
Okay, and I assume that, well, correct me if I'm wrong, that the fact that the business is vacant is not relevant to having to obtain a permit for the work that they had done?
Yeah, seeing as the work's already been done, it's not relevant at this point.
Yeah. Okay. All right. Was there anything else you needed to add?
No, ma'am.
Okay. I'm going to admit the case file as an exhibit as well as the PowerPoint presentation. I find the notices were properly given in this case, and I find that respondent in this case failed to correct the violation by the time specified in the special magistrate's prior order in this case, and the fine will be imposed as set forth in that order and will continue to run until the property is brought into compliance and an affidavit of compliance has been filed by the code inspector. Respondent shall notify the code inspector to verify compliance.
Thank you.
All right, this is DEL 24-004 A and B, Massey, 1139 Humphrey Boulevard. Go ahead.
Hi. My name is Janice Palasic. I am employed by the City of Deltona as a code compliance officer. This will be Massey case number DEL 24-004A and B. The City of Deltona versus Hugh H.C. and Sonia Harvey and Harvey Trust. The property address is 1139 Humphrey Boulevard. The parcel ID number is 813-044-020-060. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation sent certified mail to the property owner at the address listed with property appraiser's records. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day that they were taken. It was ruled on January 24th, 2024, that the property owner was given 30 days to comply. The owner did not come into compliance within those 30 days and has been receiving a fine of $50 a day, $25 per violation, since February 23rd, 2024. As of today, the property has accrued a total fine of $4,500 over 90 days, or $2,250 per violation. The city is requesting that the fines continue at $25 per day, $50 per day, $25 per each violation.
Okay, so can you, so for violation A, this was related to the garage door?
The garage door is still in disrepair. It's still damaged and bent at the bottom part. It's missing some panes of glass above, and on the left side, it's hard to see from the other photo. It's still damaged on the bottom section of the door.
Okay.
And the second violation is for the property numbers, the two that are missing in the middle.
Oh, right. Okay, did you have anything else to add?
No.
Okay. I'm going to admit the case file and the PowerPoint presentation as exhibits. I find the notices were properly given in this case, and I find that respondent in this case failed to correct the violation by the time specified in the special magistrate's prior order in this case, and the fine will be imposed as set forth in that order and will continue to run until the property is brought into compliance and an affidavit of compliance has been filed by the code inspector. Respondent shall notify the code inspector to verify compliance. Thank you.
Thank you.
Okay, this is DEL 24-023, Massey case, 2857 Cortlandt Boulevard. Go ahead.
My name is Janice Palasic, and I am employed by the City of Deltona as a code compliance officer. This will be Massey case number DEL 24-023. The City of Deltona versus Sway 2014-1 Borrower LLC. The property address is 2857 Cortlandt Boulevard. The property ID number, the parcel ID number is 813-032-840-060. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day that they were taken. It was ruled on February 28, 2024, that the property owner was given 30 days to comply. The owner did not come into compliance within those 30 days and has been receiving a fine of $25 per day since March 29, 2024. As of today, the property has accrued a total fine of $1,375 over 55 days. The city is requesting that the fines continue at $25 per day.
Okay, And so this was for a fence that was in disrepair, correct?
Yes, Your Honor.
And it's hard to see in the picture. Can you point out to me what the issues still remaining are?
There's still that small section of fence that's on the left side of the property that has not been removed.
Okay, let me look
It's hard to see with
Yeah.
the lighting and the sun, but there's 2 panels on that left side that have still not been removed. I don't know.
Are they leaning?
Yeah, they're leaning into the bushes, into the palms.
Okay.
It was hard to get a good photograph.
I'm sorry?
It was hard to get a good photograph with all the
Yeah, it's just hard
Foliage
to
back
see
there.
with all of the bushes, I guess. All right, so, but,
see kind of the post, part of the post is still over there.
okay. But you were there and observed today that it's still, several of the panels are still standing and
Yes,
basically leaning?
Yes, Your Honor.
Okay, all right. Did you have anything else to add?
No.
All right. I'm going to find that the notices were properly given in this case, and I'm admitting the case file and the PowerPoint as exhibits. I find that the respondent in this case failed to correct the violation within the time specified in the special magistrate's prior order in this case, and the fine will be imposed as set forth in that order and will continue to run until the property is brought into compliance and an affidavit of compliance has been filed by the code inspector. Respondent shall notify the code inspector to verify compliance.
Thank you.
All right, this is DEL 24-057, 1832 Villa Drive.
My name is Janice Polacic, and I am employed by the City of Deltona as a code compliance officer. This will be case number DEL 24-057, the City of Deltona versus Adam C. Cavern. The property address is 1832 Villa Drive. The parcel ID number is 813-036-150-210. This is a violation of City of Deltona Ordinance Section 66-57, which states that no person in charge or control of any property in the city, whether public or private property, whether as owner, tenant, occupant, or otherwise, shall allow any wrecked, discarded, junked, abandoned, inoperative, discarded and/or partially dismantled vehicles or parts of vehicles to remain in such property longer than 5 days, unless such vehicle is located in a fully enclosed or capable of being fully enclosed building such as a garage or shed. For the purposes of this section, a carport does not constitute an enclosed building. Corrective action for said violation is to remove, repair, have a current tag on the vehicle or put inside a fully enclosed structure. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with property appraisers. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day that they were taken. This case was created on February 17, 2024, after addressing a complaint on the property for an RV being improperly parked. I noted that the vehicle had an expired tag from 2017. I placed a door hanger with the violations as well as the corrective action on the door after an attempt to make contact with the resident was unsuccessful. Resident Adam Cavern then contacted me via phone, not understanding the violation. I went to his home on February 29th, 2024, and explained to him that the RV had an expired tag and in accordance with the city ordinance was considered inoperable. The resident was not receptive. He then became very belligerent and went inside of his home. On March 16, 2024, after verifying the vehicle was still not in compliance and had an expired tag, I posted a 10-day abatement to the property as well as sent a certified letter to the property owner. On April 12, 2024, after verifying the plate was still expired, CNS Towing was called to abate the RV. They were unsuccessful with being able to abate the RV due to the liability and the inability to determine if anyone was living inside the RV prior to them towing it. On April 26, 2024, per Supervisor Gibson, it was determined that a notice of violation would be sent certified mail to the property owner. On May 1st, 2024, it was again determined that the notice of hearing would only be sent certified mail to the property owner. An affidavit of service was also completed. As of today, May 22nd, 2024, the property is not in compliance after verifying the VIN number and plate showed no current registration. And I have a copy of what we ran in the system that shows that the tag has expired in 2017.
Okay, so in the picture, I'm looking at like a trailer, and that's sort of
It's blocking the plate that's on the back of the RV.
okay.
However, we did run the VIN number that was associated with it as well as the license plate, and it's still coming back as expired.
Okay. All right, well, what is it that you're asking me to find? Because under this section, it just says that the special magistrate can find that a violation exists and provide additional time. So I'm not sure what you...
There's no current tag on the tag that's on the vehicle is expired. It has to have a current tag. I can give you the paperwork that's showing that in the system it still is an expired vehicle, so it is still considered inoperable.
Understood, and I don't disagree with that. I would find that a violation exists, but the remedy that is provided in the code is simply for me to say that a violation exists and provide additional time for them to comply.
Right.
So I don't know, which I can do. I can issue an order.
Right. I would like to request 30 days for the property to come into compliance, or a
Okay.
fine of $25 per day.
Well, again, I can provide 30 days, but the remedy is there. I mean, in the code, it doesn't provide for a daily fine. It provides for abatement, and you've already tried that.
Right, yeah.
So I'm not
Unsuccessfully.
sure what you would like me to do with this case.
We're going to continue this with, maybe look at the ordinance and come with the ordinance that it does provide us to put a daily fine on.
Yeah, I mean, 66, and let me just say where it, I believe it's 66-63 is where it talks about removal and impoundment from private residential property. And it basically provides that the special magistrate can, find whether a violation exists and grant the owner additional time. Nothing in this section states that I, impose daily fines. So that's where I'm struggling on this one.
Understood. We'll come back to you next month reviewed under the correct ordinance.
Okay, so you just want me to continue this
Yes, ma'am.
case then? Okay, so we'll go ahead and continue this one to the July 2nd meeting.
Okay, thank you.
That's it? Wow. Okay. So is there anything that we need to address before we adjourn?
No, we appreciate you allowing us to change the June's special magistrate to July 2nd, which is a Tuesday. We have a budget workshop throughout that whole week in June, so we appreciate you allowing us to change it to that date.
Sure. And do you anticipate there being the normal meeting in July at the end of the month as well?
That's correct. We're going to keep it
Yeah.
the same one. Yep.
Okay. Okay. Thank you. We'll go ahead and adjourn.
Thank you.
Thank you.